In a unique order passed earlier this year, the Disciplinary Committee of the Bar Council of India has levied a fine of Rs 50,000 on a lawyer on account of professional misconduct by filing multiple cases. The complaint was lodged by a man against his estranged wife's lawyer, who also happens to be the respondent wife's brother. So what was this case all about? The husband in this case is an Indian origin US citizen. Parties got married in the year 2007. Following matrimonial disputes while they were living in the US, the couple separated in 2012 and the couple officially got divorced in 2013 by a local court in the US. The couple also has a minor daughter who is also a US citizen who was 1 year old when the wife left the company of the husband and returned to India. So what was the submissions by the husband? The matrimonial matter was being heard in the Circuit Court of Virginia, USA, when the respondent wife illegally abducted the child and returned to India. She was found to be in contempt of the local court in the US, and only after she returned to India, the respondents, that is the wife and her family, took advantage of their legal background, filed false and frivolous cases not only against the complainant husband, but against his entire family who had been living in different parts of the world. Due to these acts, the complainant has suffered at the hands of the respondents, and he further stated that respondent number 3, that is the wife's father, who was a witness in one of the proceedings, he himself was conducting the case on behalf of the respondent, which was not permissible under the law. What was the defense given by the respondent, that is the wife's family? Now, the respondents, all of them who are lawyers, they denied these allegations levied by the husband and submitted that they had only exhausted their civil remedies, which were available to every Indian citizen. Adding further, the respondents emphasized that an advocate cannot be debarred for exhausting his or her judicial rights. Now, what did the Disciplinary Committee of the Bar Council of India have to say in this? The Bar Council of India was hearing this appeal, which was filed by the husband, against an August 2021 order passed by the Disciplinary Committee of the Bar Council of Punjab and Haryana. After going through submissions from both sides on record, the Bar Council of India, via its 18th March 2024 order, observed that this committee is of the opinion that exhausting legal rights is a fundamental right which was granted to all the citizens by the Constitution of India. It cannot be curtailed irrespective of caste, creed, religion, etc. of an individual. But in the present case, it appears that the documentary evidence annexed by the complaint that the respondents have filed number of cases against the husband and his family with the bare intention to harass them, the same was evident from a June 2015 report which was filed by the Deputy Superintendent of the NRI wing. Adding further, the committee said that from the perusal of this admitted case, the respondents have left no stone unturned to implicate the complainant in false and frivolous cases, which is not expected from a common citizen. Coming down very heavily on the misconduct of the respondents, the committee remarked that it was evident that the respondent number 1, which is the wife's brother, in connivance with other respondents, have not only given statements before competent authorities, but at the same time, they are also conducting cases on behalf of the wife, which amounts to professional misconduct as described in the Bar Council of India rules. This order further states that the wife's advocate brother had filed a case under the Domestic Violence Act on behalf of respondent number 2, which is his sister, and respondent number 1, who happens to be the father of the wife, has deposed as a witness in the same case, which is a violation of Part 4, Section 2, Rule 13 of the Bar Council of India Rules of Professional Standards. To this, the committee even added that they were of the opinion that being the brother of the respondent number 2, respondent number 1 acted in a careless manner which is not expected from a lawyer. However, the committee further stated that despite the misconduct, they could not ignore the relationship between the respondents, and thus, taking a lenient view, the committee imposed a fine of only Rs 50,000 on respondent number 1, that is the wife's brother. Respondent number 2, that is the estranged wife, and respondent number 3, that is the estranged wife's father, were further reprimanded not to get involved in such activities in the future. The respondent advocate, that is the brother of the wife, was directed to deposit the fine amount in the Advocate Welfare Fund of Bar Council of India within 1 month. If he failed to do so, he would be debarred from doing practice for a period of 2 years. And in case of any non-compliance of these orders, the Secretary Bar Council of Punjab and Haryana was directed to initiate the publication proceedings. This article was first published by Punjab Kesari on 30th April this year, and we reached out to the husband to understand the matter from his side. Speaking to Voice for Men India, the husband shared that his ex-wife comes from a family of lawyers. Both his ex-brother-in-law and father-in-law had filed a number of cases against him and his family in different places. So the brother would file in Mohali, the father would go and file in Kharar. And in all these cases, they took ex parte orders against him and even filed cases against his family members who were living in different parts of the world at that point in time. For example, his sister, who is a doctor and who lives with her family in Poland, and his other brother, who is a chartered accountant, who was living with his mother in Australia, none of them had been spared from these false cases. His family members have all faced the brunt of harassment along with the husband. None of them were even able to travel to India for the past 12 years. So what is our take in this? Should a wife who has been living with her husband in a different country be allowed to return to India and file cases in the jurisdiction where she has not even been living for the past so many years? Let's assume there were actual cases of domestic violence in the matter, and the wife returns to India and files multiple cases against the NRI husband. Now, how do you expect an investigating officer sitting in India to go and investigate what would have happened in the four corners of the wall in the US? This is not a one-off case. There are many NRI husbands who have been facing the brunt of this absolutely lopsided system in India. And in many cases, these husbands keep traveling to multiple courts in India for years and decades. And in the end, there's no solution, the cases keep dragging, or they finally give up, pay a lump sum alimony, and try to end the matter as soon as possible to save themselves from further harassment. As far as children are concerned, by the time there is any logical solution or a final verdict that comes out from the court, the children who have been abducted by the mothers and brought back to India, they are anyways completely brainwashed. They do not even recognize their fathers. And in the end, it is a win-win situation for the wife, who possibly may or may not have been the actual victim. I'm leaving the entire Bar Council of India order in the description link of this video, or you can also read it on our website, voiceformenindia.com. You can follow us on our social media handles, which is Instagram, Telegram, Facebook, X, which was former Twitter. The ID is @voiceformenin. And you can hit the bell icon and subscribe to Voice for Men India for many more videos, many more case studies, and many more stories with regards to anti-men laws in India. That's it from me as of now. Thank you very much for watching. Namaste. Jai Hind.